Thank you, Margaret, Christy. Thank you for inviting me today. It's a pleasure to be with you. When we initially began to discuss what we would talk about today, it began as a do's and don'ts regarding state procurement, but do's and don'ts are an iterative item for the processes that you undertake. So we decided to put together a presentation on how we go about procuring items for the state, and then we'll address some do's and don'ts under various of those topics. So without further ado, we'll just run right through this. As we said, if you've got questions, keep them in mind, and we'll address those afterwards. And so away we go. We're not getting response here. Okay, we're just going to entitle it Government Procurement Contracts to keep it short. First of all, as you can see, our state level contracts for goods and services are established through one of three processes: a simple request for quote, bidding, or request for proposal. Every process begins with a request to our department, which is a central procurement enterprise, and we're located in the Hoover Building in Des Moines. We'll receive those from agencies or authorities to obtain their goods or services. At that time, it's assigned to a purchasing agent, and a contract resulting from either the RFQ, bid, or RFP is available for use by the requesting agency or authority, and it may also be made available to all state agencies, political subdivisions, and entities. And here's the first do on that procurement. We need to state in a bid or an RFP the intent to make that available to all political subdivisions. Without that statement up front, we put ourselves in a position of not allowing it to be available for entities, and if we did, we could be in violation of administrative rules. It could also be subject for an appeal later on if it occurs. We'll start with purchase requests. The request is received from the agency, we assign it to a purchasing agent, then they will work with the requester to determine if it's procured through an informal or formal competition. That's the RFQ, the bid, or the RFP. And that's dependent upon the cost and whether it's a good or a service. And you'll see throughout here, I will reference various areas in the IAC for your benefit. If the item's an RFQ, essentially the item specification is thoroughly known. Its value is going to be less than $50,000, and 3 informal quotes are used for the purchase. You'll find that under IAC 117.3. as well as 118.5. The informal quote can be obtained through a fax, a telecon, or email, and it's as simple as that. Sorry, I went backwards. It's not indexing properly. Christy, I'm having a technical difficulty here. No, it just keeps indexing back to the same screen.
Let's try. Let's try relooking it. There we go. Is that the next screen?
Okay.
There we go. Not quite sure why I was doing that.
You skipped a page on me. Yes. We need to go back. Okay, now we're back. Thank you. Sorry for the inconvenience, folks. If the item's a bid, as we've said, the specification is known, the value exceeds $50,000. Formal competition is required, and a bid evaluation is based upon simply meeting the specification requirement and the total delivered cost. If it's an RFP, The spec, the terms applicable to the specification, and evaluation criteria are provided by the requester. At that time, the purchasing agent will work with them to be certain that it meets their requirements. Now, once they complete the RFP documentation, and we have to emphasize very clear specifications, specific technical and financial evaluation criteria and process, at that time, we'll contact our AAG to determine if they want to thoroughly review it or if they do a simple review to see if we're just utilizing our standard terms and conditions at that point. The vast majority of the solicitations at this point will contain our standard terms and conditions and any of those that are specific to that particular acquisition. So a certain due here is for everybody involved to review the specifications and then be very certain of the evaluation criteria in order not to jeopardize the decision. Any indecision in your evaluation criteria, which must be done in a consensus basis with your team, does lead to potential problems. A don't here is do not overlook the need for your legal review prior to issuing the RFP. Even if you're using your standard terms, at least have we have our AAG look at it to be certain. And it may also be the AAG working with that particular agency. And additionally, another don't is we do not allow vendors to have any discussions regarding the RFP prior to the issuance nor after the issuance unless those discussions are only with the issuing officer, which in our case would be the purchasing agent. We make that very clear in all the specifications that are issued. Now we come to issuing our bids. All bids and RFPs are publicly advertised in accordance with administrative code. First, they're posted to the state's targeted small business website 48 hours prior to a general public posting. This allows the targeted small business community to review what we want, see if they can participate, and we have authority through code to award business to them if it equals $10,000 or less without any further competition, any further quotes. It's specifically spelled out in our code. Once completing that TSB posting, we'll then post all bids and RFPs on the state's bid opportunities website for all vendors to see. The recommended posting time will vary from 5 days to 4 weeks or more, depending upon the subjects. We recently had one out there for 6 weeks, and that was at the request of the agency and the complexity of the entire procurement itself. Additionally, we've just started a new service called Vendor Self-Service, and vendors who register on our new I3 Vendor Self-Service site will automatically receive email notice regarding bids and RFPs on commodities for which they have registered. Those commodities, by the way, are found in the National Institute of Government Purchasing's commodity list, and there's about 5,000 there. We've narrowed it down to a 3-digit code, which underneath each one will potentially encompass from 1 to 25 different categories. So rather than a vendor having to very discreetly determine, like roofing and insulation, if they just put down a category of roofing, that just gets encoupled within it. And lastly, all construction bids and RFP are also advertised in various newspapers, and the advertising will depend upon where the project is going to be, as well as in Des Moines. Now, a don't here is we do not deviate from our required process. We maintain that we're going to stick to that. And if we do not maintain to our process, we open ourselves open for an appeal. Now, a do for this is that once we advise all parties of the RFP or the solicitation, we advise them that the evaluation sheets that we have that incorporated with us are held to us. We do not disclose those to others except for everybody involved within the evaluation. We also advise those individuals not to discuss it with anybody outside of the evaluation process. We don't want to take any chance of jaundicing the decision or creating a basis for appeal. The bid and RFP receipts. Each bid and RFP is issued with a due date and time. A due for that is we will extend a due date for a bid or an RFP One is determined necessary. Determination of necessary will occur internally if we see that we may have missed something within the bid. It's unclear. We may receive a question from one or more participants that potentially somebody might be missing. We come back internally, discuss it with the agency or the evaluators, and at that time we have the discretion to cancel that solicitation and then reissue it correctly. And we will publicly advertise that. Adult with that is that we will not extend any due date to accommodate any vendor. We have had vendors call us and say, my estimator is going to be on vacation for 2 weeks. We need it extended. We will not do that. It's as simple as that. We just don't. Bid and RFP responses received prior to a deadline are all accepted for review, and that's an initial review. Bids and RFP responses received after our deadlines are rejected. Simple example, we had an item occur approximately 2 months ago where a vendor called to ensure that his bid was received. Actually, it was submitted to an RFP. It was actually received 1 minute after the deadline. His contention was that it must have been held up somewhere, and it wasn't. Everything was date time stamped, and so we just provided the evidence, and it was rejected. He was considering appeal, but when we provided them photocopies of the receipt time, we didn't hear from him again. All accepted responses are reviewed to determine if they are compliant with submittal documentation requirements. Those are spelled out in the RFP or the bid, and that can include anything from the specification for the item that you're bidding to audited financial statements or other required certifications, depending upon the subject matter. A due for that is that we be certain that all requirements are met. Simple as that. All compliant responses are evaluated, non-compliant or not. We occasionally do receive an inquiry from a vendor after the evaluations are posted, wondering why. We do tell them where they were not compliant. Otherwise, they won't be able to correct their practices going forward. Bids and awards. After we evaluate all our solicitation responses, we'll select a vendor. And then we'll provide a notice of intent to award. Each vendor submitting a response is notified. And we also make those publicly available to all other parties upon request. Bid responses which meet specifications and are at a low cost are all selected to receive a contract award. RFP responses, which meet criteria set forth in our RFPs and evaluated as the best overall proposal, are selected to receive contract awards. The big don't here is that we do not deviate from our evaluation process. If it's determined necessary to revisit the evaluation process, the solicitation will be canceled. Because to deviate from the process set forth, at that moment you just lost your integrity for the whole, not only for that solicitation, but potentially for the parties involved. A due for that, again, is necessary to cancel the solicitation, revisit your evaluation criteria. Or it could also be that after the fact we find out that somebody involved in the evaluation may have a prejudice, and if so, they need to be removed from the evaluation team and replaced. Whether or not it was a bid or an RFP and the award selection is determined, we issue the intent to award. We post it for 5 business days. And at that time, only unsuccessful bidders may file for an appeal of the award. And again, all of these procedures are set forth in our administrative code. If appeal is not received, and granted, we do have some that may have come in 6 days or 7 days, and those are rejected. But if one is not received within the time frame, we'll proceed with our contract award, and we'll prepare all applicable documents. A due here is to be certain that all the documents are reviewed by the agency as well as our Attorney General, to be certain that we have no errors and we're all internally compliant with our solicitation and any applicable administrative rules and sometimes code. And of course, we always run into the appeals of our solicitations. If a party decides to appeal a bid or their award, we have the process fully set forth in Chapter 117 of the Administrative Code. And keep in mind, the only parties that can appeal the award are those who did submit a response to the bid or to the RFP. Now, circling back to the RFQ, we don't have bids, we don't have appeals regarding the quote items. Those are rather rudimentary items and typically deal with common commodities and goods and very small services. On a notice of appeal, it has to be submitted to the Director of Administrative Services within 5 calendar days of the award notice. If it's not submitted within that time frame, it's rejected. Upon receipt, the appeal is handled as a contested case proceeding pursuant to administrative rules. The Department of Inspection and Appeals is notified at that time, and an appeal hearing date is set. That date shall occur within 60 days of the date the notice of appeal was received. So as you can see here, there's no delay from the time it's received in our enterprise to the time it goes over to DIA. At that time, I received notice also. I don't receive forward notice of an appeal coming in, but once they come into the director and the director issues a notice, at that time is when I also find out, as well as my purchasing agent involved. Now, the written notices of the date, time, and location of the appeal hearing is set and is sent to the appealing as well as the awarded vendors. All participate. Now, keep in mind that vendors may withdraw their appeal, providing written notice to the Department of Inspection Appeals. Now, they can provide a reason why they want to withdraw it, or they can just provide notice that they are withdrawing it. There's no requirement set forth in the Administrative Code for them to declare their reason. Now we get to our award appeals. The appeals are heard by an administrative law judge who then issues a proposed decision. The appeal hearing time takes what it takes. There's no set time frame. Then in conjunction with that, there is no time frame specified for when a proposed decision must be issued. I must find that I found that quite interesting myself, and I looked through the code, and I couldn't find anything. I couldn't find anything in administrative rules. So when in doubt, as I said, check with your AAG, and they too confirmed that there is not a time frame set forth. Now, a big don't for this is do not enter into a contract with any vendor while an appeal is in process. Another don't is don't even begin negotiations because everything remains discoverable. And I'm not an attorney, but I always believe why help somebody out with their own case? If the appealing party accepts an ALJ's proposed decision, the procurement continues, the purchasing agent finishes the documents, it goes through everything that's necessary, from legal review back to meeting with the agency to be certain that they still want to continue it. They can at times suspend the procurement activity. It does not change the award. It changes nothing else. They will just suspend it, and that can be for their internal reasons, and they discuss it with us, and then we proceed from there. Now, a big do here, again, is to be certain that we go through full legal review before anything is signed. Now, if an appealing party does not want to accept the ALJ's decision, they can then make an appeal to the Director of Administrative Services. And that has to be done within 15 days of the proposed decision. Now, getting to the other appeals. if they appeal to the Director of Administrative Services, each party has the opportunity to submit their briefs in either in opposition or support of the proposed decision. Then, after receipt of that, at the Director's discretion, oral arguments may be held. Now, a big do here is for us in procurement and the purchasing agent to be prepared to assist legal counsel. That preparation is going to include everything from the original solicitation document, bids and/or proposals received, information regarding the evaluators, simple of who the evaluators were, the evaluation itself, all documents that they believe they require for their position. And this is for our legal counsel, that is. The director will not take any further evidence and shall not consider issues that were not raised at the initial hearing with the ALJ. If the director holds oral presentations, they'll issue a final decision not less than 30 days after notice of appeal is filed. Now, I will admit, when I saw that in the administrative code, I questioned, why would they say not less than 30 days after the appeal? Well, if you go back to the administrative code, you'll see that I have just put in salient points here, and it's rather exhaustive information in the IAC regarding this process. But when you see a lot of the timeframes involved and the timeframes allowed for counsel to submit a final documentation supporting their cases, that by issuing a not less than 30 days, it allows plenty of time for counsel to submit their information to the director for additional review. So having it, within 30 days compromises their time frame, and the process itself becomes compromised in that regard. All right, getting to the end of it, on appeal rulings. If a vendor is unsatisfied with the proposed decision of the ALJ and the final decision of the Director of Administrative Services, that vendor, the agreed vendor, may file in district court for judicial review. And with that can include with or without injunctive relief. Now, in closing, all I want to offer you to is the facts that public procurement and the contracting process is intended to provide open, fair, and competitive procurement opportunities to all vendors. And I will admit that that is in somewhat contrast to the environment in which I spent the majority of my career. But that too was an area where we intended to provide open, fair, and competitive procurement opportunities. It's just that the guidelines that we utilize were totally dependent upon the particular corporate culture that we were in and the rules in which we were to operate. Coming from the private sector to the public sector, at first I was quite amazed at the breadth of the code and how items apply. But the more I've been exposed to it, the more I've gotten in depth with it, I truly have come to appreciate the manner in which the code has been established and how the administrative rules have been established to administer the code. Because coming from one side of the street to the other, if I want to put it that way, as I truly see now how in public procurement, every effort has been made, not only by business people and legal counsel, but everybody involved, to make it a very fair and open process. And I support it, and I will continue to support it. And one thing I believe is in my charge as I go forward in time is that there are some items in administrative rules and code that were written at a point in time which were extremely applicable due to the nature of business development, contrasting how things were in 1975 and 80 to where they are today. We're an information-driven society. Well, if you look at that and you look at how we have code and rules to apply to procurement, many things were written in a very static mode to address what was occurring at that point in time. And that was necessary, there's no doubt about it. However, there are some that were not written in a dynamic fashion so that they could go forward in time to apply to different circumstances. Many do, of course, Many cannot and should not. But then there are some just based on the procurement side, whether it be markets or economics that we address. But none of it can be done in a manner to compromise open, fair, and competitive procurement opportunities for all vendors that want to do business with the state. You see, we believe that the goal of government procurement is to award timely and cost-effective contracts to qualified vendors for the provision of goods and services to support government operations in accordance with the procedures established in the state's public procurement rules. I support that. I will continue to support it. And I appreciate all the support that I get, not only from our purchasing agents and other individuals on our staff, but the never-ending support and guidance provided by the legal counsel that we deal with. And that's not only the counsel from the Attorney General's office, but also counsel within each agency. As I said earlier, I'm not an attorney, I'm an economist, and I'm a glutton for information. So information I can obtain and guidance that I can obtain from legal counsel, I truly respect and I do appreciate it. And I will always continue to use counsel. So with that completes what I have to offer you today, and I welcome any questions you may have.
If you have a question at this time, you can use your chat box feature to type in a question. If you have a question at this time, you can type in a question in your chat box. Robert, did you have any questions?
I just wondered maybe you could just talk about some of the questions that seem to come up a lot. So we can get a little more time.
Okay. Margaret has asked me if there are questions that are frequently posed by vendors when we deal in solicitations. The first one that comes to mind is vendors quite often ask, is a solicitation going to be for vendors in the state of Iowa or all vendors? Are we closed? And no, they're open and fair to all. It's not geographic specific. There might be a time when there could be a geographic specific requirement, but that's reviewed in accordance with the actual requirement, discussed with counsel, discussed with the agency, and in my 2 years here, I have not had any of those occur. Now, of course, it does happen in the private sector all the time for various reasons, but I haven't run across it here at all. Another common question is, we have a lot of people from the outside that monitor the bid opportunities websites that we've got, and they will inquire about a bid, and they will want they'll want copies of all documents for all the bids, including evaluations. They're welcome to have those once we've issued a notice of intent to award. But every request I have received has come in prior to the notice of intent to award. And the only thing we do is advise them that upon issuance of the notice, at that time, they become a public document. I had that challenged once, and I just advised them to contact the Attorney General's office. I gave them the item in the code, gave them the code number, and the individual was quite nice. He called me back, and he actually apologized, and just said that he'd be getting hold of me on such and such a date, which he did, and we provided all the information. That's all. It's a very common question. When we deal with RFPs, a very common question is that how do we vet out the individuals on the evaluation committee to determine that they don't have a vested interest in the outcome of the item? That's done on each individual RFP where we have an evaluation group. We have the purchasing agent look at the agency because you need to have somebody agency specific. We also need to have totally independent parties that have the capability to read a specification, understand it, and sit in a collaborative manner to evaluate. Our evaluations are done in a consensus manner. If you do individuals, you end up with idiosyncratic reasons to weigh your evaluation to one point or another. And when you're doing that from a statistical viewpoint, you can end up with a weighting factor that will skew an evaluation in a grossly unfair manner. And when you do that, now you've jeopardized the evaluation, you've effectively rendered it useless. And so by going through and look at the people involved, seeing what they do, having them declare, and it is a declared statement. We did author, but once I arrived here, and I'll just provide this to you, there was nothing that I found in past practice with my enterprise for individuals to declare a conflict of interest due to related party. There are other requirements for declarations under ethics that we must provide, and that's essentially financial. But there can be other matters of conflict of interest. That conflict of interest has been reviewed by the ethics group as well as the auditors and the Attorney General. It was authored, I wrote it, and I worked on it with Ms. Susan Heminger, and we've got a very fine document where they will declare a conflict of interest. And it provides them not only the opportunity to recuse themselves from participating in a solicitation, and this is for my purchasing agents as well as evaluators, they can recuse themselves from that, or during the process of the solicitation or the evaluation, information becomes known that that individual had not known at the time. It provides them an opportunity to withdraw. And I've felt that to be a very fair item to provide to all participants because it does provide the avenue for somebody to withdraw so it doesn't compromise items so we have to start over again. If that happens, and it's happened once since I've been here, and that was with my own group, at that time we reassigned the project to somebody else. We stopped the solicitation, canceled everything, gave it to somebody else. They took it at that point in time there. So it's very important to do. And I have been asked by outside people whether there's conflicts and explain to them what we're undertaking to prevent it. And it's been a very worthwhile effort. And everybody's required, every year my purchasing agents are required to sign it. We do have the same item happen, as I said, with evaluators. And that's a standard procedure. We do not deviate from that. When we're dealing in RFPs and we're spending the taxpayers' money and we're operating in accordance with code of administrative rules, I tend to be very cold and calculated, but that's what I'm charged to do. These are the rules. It's my responsibility to ensure that procurement is done in accordance with law. And I don't mean getting up and pressing the law to the point of pushing it over the edge. No, that is not appropriate. It's also not ethical. And ethics is another item that is quite important. Yeah. Our Western society has a tendency to forgive moral trespasses, but they will not forgive an ethical trespass. And in my role, I have to ensure that we maintain our ethics. Because again, without ethics, you begin to compromise not only your integrity, but just about everything your name is on. Everybody's going to question it. And I don't mind if people question me about how I ride a bicycle or build audio gear, but I don't want them to question my business ethics. And I don't want any of my staff to have their ethics compromised. So I will also add that I've truly enjoyed working with my staff. I enjoy working with agencies. And the assistance of the Attorney General's office has been immeasurable to me. You know, I'm used to coming from a corporate environment where I can go to the 27th floor, the 5th floor, wherever I'm at, and I've got counsel there to work with me. But they become in many cases, subject matter experts, and they are channeled into certain areas. But yet, I've had the pleasure of working with counsel that their knowledge expands, like a rainbow. It's got different colors to it, and they can step in various areas. But yet, they're also the type that say, well, now you're getting into area X. I need to call Jane Doe or John Doe and get them involved. And I like that, because to me, when you've got more people looking at the same puzzle, you figure out better ways to solve it, and so on. But that's about it. Do you have something else, Margaret?
What, when you're reviewing the proposals and they first start coming in, are there any kind of red flags that, can tend to jump out at you, or things that maybe apply to more than one type of project, and where you go, wait, we need to look at this a little closer?
So your question, when we receive responses, are there any red flags?
Yes.
The first red flag is if somebody doesn't sign it. That's the first thing that we see. And we will question that, because they must be signed. And they must be signed by somebody who has been provided the authority by the vendor to sign for them. We actually have had something recently where somebody was awarded a bid, and when they received the notice, they came back and said, well, the person that signed this wasn't authorized, so we want to increase our prices. The purchasing agent, acting in accordance with rules, said that provide us a statement that this person was not, provide us in writing they were not authorized to sign. And they did, and then it came to me regarding the bid itself. We're told that they had not declared anything. They're going to have to honor their bid. It's as simple as that. They submitted it. It was represented that the individual who signed it had the authority to do so. They gave no declaration. Looked at that as their window of opportunity to decide that, no, we're not going to make enough margin off this. We want to go ahead and withdraw. The vendor was contacted, and the vendor decided, no, we'll go ahead, thank you. As simple as that. That's one red flag that we look for. The other red flag is to review mandatory submittals. If they do not provide a mandatory submittal, we don't question why, they're just gets eliminated. Those are yes or no's mandatories. Other red flags, sometimes it's hard to tell. There's not really some common red flags. You have to see their response to see if they actually address what you want versus provide what they believe you want. And when they do that, it leads us to believe that they have not read the specification. And so they are hoping to be awarded on a low dollar basis only. And that is why we're better off issuing more RFPs at times than bids, when there might be a gray area that has to be set down to an evaluation in accordance with specific criteria. So those are the simple red flags. Others can show up at times where people miss word items, they don't include information required. But another red flag is the people that say, well, it was there in time, I know it, I have proof. Well, we have the proof too, so it's not a red flag, that's just a he said, she said, whatever. Now, procurement can be interesting. It can be rather rudimentary at times, but there's enough interesting times to keep us all busy too.